Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which will be of great relevance to members of the family law bar and also anybody who practices in the family law area, both in terms of legal practice and litigation and also in terms of mediation. The book we're looking at is this book here. It's called Family Mediation, Contemporary Issues, and it's been written by two people, Marian Roberts and Federica Moscati. Sorry, I do apologise for getting the name wrong. Now, it comes to us from Bloomsbury Professional Law, and I think it's an important book because it recognises the importance of mediation in the process today of dealing with, generally speaking, most family disputes. Not all, but most. So the headline we've given, and Elizabeth was the lead writer on this particular book, is Where Mediation Meets the Law, essential reading for family law practitioners in England and Wales, as well as Scotland and Northern Ireland. Now, the reason we say that is because quite often the books we review are only relevant to England and Wales jurisdiction. This one covers a much wider jurisdiction, and of course the concept of mediation does cover much more than just England and Wales. Of course today a very large number of cases we have are well outside the very narrow boundaries of our own jurisdiction. Let's have a look at the book first of all. It's a paperback. There it is. It came out a little bit earlier this year in May. That's the back of the book. You can see it's a lightweight. It runs to 350 pages. The index at the back is by page numbering, and it's quite a useful index which you have at the back. And then you've got some end notes with the chapters which you can see there just before the index starts. The end note being basically references and a whole range of other points, including case law, of course. If we go to the front, there's the first page there. Then blurb from Bloomsbury, and then information about the two writers of this book, Marian and Maria. Marian is a barrister, and Maria is an Italian advocate who's an academic. There are also a lot of people who've been contributors to this work. You can see their names there. I can't mention all of them by name, but you can see a large number of people have been involved. And then we get to the contents section, and then you can see the various chapters running all the way through, and there are in fact a total of 16 chapters, and then you've got the index at the back. Then you've got an introduction. You see it goes straight into the work itself, and then you've got just running through, you can see the way it's run through. There are no footnotes, but what you do have, as I indicated, is you have at the end of the particular chapter, and each case you have what are called references. That's obviously mainly the bibliography, and you've also got what they call end notes, which are actually the relevant pieces of legislation and the case law. There isn't in fact a list of statutes or cases, which is unusual because normally you do get that with these books, but you can see again how it goes. I did find this quite an interesting book because it's a book that you can read through. I think it's interesting because I'm a mediator as well as a barrister, and I did find it of very substantial help, and I think it would be useful both for lay people and also of course for professionals, both mediators and people like myself who practice at the family law bar. So what do we say about it? This current wisdom in the legal profession, particularly amongst family lawyers as well as members of the judiciary, is that opting for mediation between disputatious clients is preferable to going to law with all its attendant financial and emotional difficulties. And of course there's the law's delay. Clearly we are at the moment on the cusp of some very profound changes within the legal system brought about by the COVID-19 pandemic. I don't know where we're going to be going later in the year because most of the hearings I've got at the moment are virtual hearings, we're not having face-to-face hearings at all. Obviously, my concern as a mediator is that if we don't have face-to-face meetings and you're dealing with people at a distance by telephone, or alternatively Skype or whatever, you've got a slightly different approach to the way in which you conduct the mediation. It still works, but I think it's a slightly different approach. But it depends very much on individuals. Obviously, because of the COVID matter, the pandemic, the legal landscape may and indeed must change. The question really then is going to be what direction we're going in, because very few of us will be able to say with any degree of certainty what is going to happen. And by what is becoming increasingly clear is that at the time of writing and delivering this particular review of this book, the means and methods by which family disputes may be settled will definitely have to undergo some sort of change, precipitated, of course, by the bizarre but necessary restrictions that we've had on lockdown, which is beginning to ease as I write this and deliver this in the middle of the year. Mediation, of course, with its now well-established principles and processes, offers what we think is a sensible and less time-consuming way to resolve a good many of the often intractable problems of family disputes. It's not a one-size-fits-all by any means, but quite honestly, mediation in many instances does work, and the reason it works is because it's not something imposed on people. It's something they've seen sense and agreed to themselves. That is the essence, in my view, of successful mediation, because they go away realising that that's the best they can get. And it's not something that some judge up there has said, that's what's going to happen, because neither side will like it. Because what is certain and well nigh indisputable is that many family law matters will in the future be dealt with in virtual hearings anyway. So why not mediate? Obviously there are some cases where you can't. When I'm doing public law child matters, for instance, there's no mediation in that at all. And obviously I'm looking specifically at private client matters for this. And the answer, of course, is because the majority of the clients today are visibly hostile to the very idea of mediation. However, obviously not to mention the expense, but little do they realise that mediation, despite the initial fee levels, which can be quite high for a day, normally work out cheaper in the long term, and you quite often will have an end to the proceedings there and then, rather than what we've got at the moment, which is an extension of time for the case to be heard, and it can run into years, and it's a big problem. It's something that most clients don't understand at all. They think, oh, we go to court once and that's it. It's not like that at all, of course, as we know. Fortunately then, for us, we've got Bloomsbury Professional Law who've come into this. Obviously, family practitioners are reliant on some of the titles they produce, and this is a very good one because they've published this at a timely and important time, and it's an authoritative contribution to the literature of family mediation. And it's certainly something that I think is extremely helpful. And of course, under the able editorship of Marian, Robson and Federica Moscati, the book provides readers with a broad spectrum of pertinent and carefully researched insights on family mediation from 17 contributors, all listed at the beginning of the book. Each of them, of course, are highly qualified, and they offer us a wealth of expertise and experience in what is a complex area of dispute resolution. And I'm very grateful to have that all brought together in one volume. So it's a valuable source of current thinking, and of course the concept is contemporary issues. That's what they're looking at, very much 2020 and beyond. So as I say, it's valuable, and it's a source, and also of course the current thinking and informed consultancy you get here in one handy volume is really very helpful indeed. And as I say, it's not something that's difficult to read. It's worth reading through reasonably at a pace, depending on what you're looking for, because the chapter headings, the 16 chapters, will give you obviously, depending on what you're looking for, particular pointers in the right direction. Of course, the book covers an amazingly wide spectrum of contemporary issues pertaining to mediation, from professional regulation and ethical considerations to the impact of domestic abuse, which is covered at the end, and the voice of the child in family mediation. Always a difficult one, obviously something the judiciary have never been very happy with at all, but I think it's becoming more important. Certainly with the most recent cases I've done, I do believe that the views of the child must actually have quite substantial impact when it comes to a final decision. In the past, and going back not very long ago, they didn't exist at all in terms of what they wanted, but times have changed. So let me conclude by saying this, that it's scholarly as well as readable, and it's a book which will no doubt be regarded as essential reading for lawyers as well as mediators. It should be in your law library, and you should lose no time, in our view, in acquiring it, if I can put it that way. Now, the date of publication of the paperback edition is cited as at the 19th of May 2020. Let's just have one last look at it. There's the front, there's the spine, and then there's the back. And then if I open it in the middle, I'm just going to pick some theories, approaches and models on the place of truth in family mediation. You can see that. Difficult one, that, because what is truth is the question. What is truth? What is the law? I mean, what is justice? These are all interesting cases, but the reality is you have to get down to basically trying to work out, not necessarily where any fault or blame can be attached, but trying to work out what the long-term plans are for the group as they part and go their separate ways. So you can see the book itself, no footnoting as I say, but what you've got there is you do have a conclusion quite often at the end of each of the chapter headings. Then of course you've got some quotes as well. Co-mediation is mentioned, which is always quite interesting. I've done some co-mediations and they work well. I'm quite pleased with them. Then you've got end notes. The reason about co-mediation, when you've got more than one mediator, is that I think it actually it instills a bit more confidence in the parties. And there's not one person as a mediator, it's two. So therefore, it doesn't look as though we're ganging up on one person. And then finally, you've got the references you can see in that particular chapter, very detailed references. And just to remind you, the index at the back is relatively small, but it should help you with what you're actually looking for. Anyway, I'd like to thank the two editors and the contributors, and of course Bloomsbury, for producing what I think is a splendid work. Thank you to all anyway. Bye-bye.